Yeah. Great, thank you. Welcome back to Senate Economic Development, Housing and General Affairs. And we are now turning our thoughts to a bill that originated in this committee, S-230, which is our labor bill. And it has had some changes and additions in the House. And we have our legislative counsel to walk us through it.
Good morning, Sophie Zidani for the Office of Legislative Counsel. And I did a quick chart just showing what the changes are.
Oh, thank you. That's so helpful.
Thank you. So, and I can put up the bill. So this has not yet passed the House. It's up on third reading today.
Thank you.
So again, as you noted, this originated in the Senate in this committee, and it essentially was covering, I would say, substantive corrections for the most part when it was here. So the first section is the one that adds in the citation to the Code of Federal Regulations relating to full-time teachers, and there was no change to that on the House side. So that you've already seen. Section 2 is the section that takes the language that was put into the Parental and Family Leave Act by Act 32 last year around self-attestation for victims of sexual assault, stalking, etc., domestic violence, and transitions that language into the definition of crime victims under the Fair Employment Practices Act. So no change except for the fact that this committee in S-230, when you passed it out, you had added in some additional language, which was that the self-attestation had to be under penalty of perjury, and the House took that additional language out. So what's in S-230 is the same language that is currently in the Parental and Family Leave Act. It's identical on both sides now. Section 3 is the section in the Fair Employment Practices Act that permitted institutions of higher education to have mandatory retirement for tenured faculty at the age of 70, which has been unlawful since 1994. So this is a repeal of that section, so no change on that. And then the additional sections, 21 VSA 383, this is under the minimum wage provision. So again, this is page 4 of the version that we're looking at. And this was House Bill 556, which I believe you have, came over here and had passed the House previously. And that you've, I think, had a walkthrough, etc. on that. But what this does is it exempts from the definition of employee under the minimum wage laws and overtime laws elected and appointed municipal officers. And this is just to make it consistent both with the Federal Fair Labor Standards Act, but also consistent with what happens in practice today. And this was something that had been requested through the Vermont
right, through the LTT.
Right. And then finally, Section 3B, this is new to this committee. This is adding some language around agreements not to compete. This would be a new section under the Fair Employment Practices Act. This was originally a subject of an extensive bill, summer working group created by the House Commerce and Economic Development Committee, extensive testimony in that committee. It was called H205. It went to the floor, and then there was a challenge to it on the floor around whether or not it should, it was to do with language that's in Title 16, an education provision around when contracts are signed by teachers. And that was, it was just a huge issue that could not be resolved under this provision. And so it was returned back to House Commerce and Economic Development. And then in the General on Housing was adding a much more streamlined version. So what this does is it simply provides a prohibition on agreements not to compete for non-exempt employees. So non-exempt employees, non-exemptees, they're not exempt from the Fair Labor Standards Act at the federal level. And typically those are your hourly folk, the ones that are eligible for overtime, they aren't, don't have advanced degrees or specialized knowledge, they're under direct supervision. So this is to prevent some of the more egregious conduct that can happen where individuals with little to no bargaining power required to sign non-compete agreements, which means they can't work for another food establishment within a 10-mile radius for a year or whatever. I mean,
Yeah,
it really restricts.
Are these non-union members? Because
They can be union members, so there's language in there that if there is a non, which again I've not seen in union contracts, but if there were to be one, if it's bargained for as part of a collective bargaining agreement, then there's been some negotiation with the employer over it. So that would be permissible, but for the individuals, you can't have an agreement not to compete. And again, these are not individuals, you know, with I don't want to say anything that's pejorative because it's not meant that
not
way.
necessarily individuals with huge means.
Right. These aren't sophisticated people with specialized knowledge. These often, if you run into it with like hairdressers and things where somebody works in the salon and then they're told you cannot work, you know, in a 20-mile radius. If you leave our establishment, and you're effectively denying them the ability to work with someone else or to open their own salon. So this is really to address the more sort of egregious incidents that happen.
So I think we need to go back to like what's an exempt or a non-exempt employee, because I don't think that's necessarily accurate that a salon employee would automatically be categorized as non-exempt versus exempt. A non-exempt employee has a set hour, wage, etc. Salon employees can have all kinds of agreements for how
Well,
they
that
work.
may be not the perfect
So-
example.
Well, but like we should know what we're talking about when we talk about
Right.
exempt versus non-exempt.
So
That's a big, that's a really interesting way to determine certain elements of labor law that I think we want to talk to like one of our state's employment lawyers about.
I mean, there was testimony on this in the
Who did they
last
hear
night.
from?
David Mickenberg, Austin Davis from the chamber. I think
We
those
have
are
somebody
the-
coming in next week.
Okay, so just to run through, so this is again under federal law, and it says usually because there are some exceptions, but so the distinction between exempt and non-exempt. To be exempt is typically you have to earn a minimum salary, a salary threshold. The current federal salary threshold is around $35,500 a year. Plus there's a duties test. So you have to have duties, again, primary duties require the use of advanced knowledge or skills, and you have the authority or ability to make decisions independently. So non-exempt, you have to be paid minimum wage. So whether that's federal or state, you have to, you know, you're entitled to receive overtime. And then there is no duties test for that. And then, so these were just some general examples. And again, you can have non-exempt employees who are paid salary, but then the employer still has to make sure they're getting paid overtime. You know, so you can't get around avoiding paying overtime if somebody is non-exempt. And then this is a very simplified overview, but there are fact sheets for each of the tests for all the different exemptions. So the goal of the subdivision A under section 3B is really to eliminate agreements not to compete again for those sort of the most vulnerable workers, lowest paid workers, the ones that have the least bargaining power with their employers. And then the second provision is specific to healthcare providers. And this was language that came from the Medical Society. This was language that had been contemplated being put in some of the healthcare bills and was taken out because their anticipation was that H205 was going to move forward, which it then did not.
So, sorry, this is page
This is page 5,
5. Yeah.
subsection B up to 3B. And so what this does is it, in contracts or agreements with healthcare providers, this identifies a number of provisions that would be void and unenforceable. And so A is essentially a non-compete, so that includes restrictions on the right of healthcare providers to provide healthcare services in any geographical area. for any period of time after the termination of a partnership agreement or professional relationship. It would limit the ability of a separating healthcare provider to provide notice of their change of employment, and then there's some additional language below on the notice. C restricts a healthcare provider from making disparaging statements. So again, it would prohibit non-disparaging clauses. It would prohibit provisions that are inconsistent with Vermont law, or provisions that require litigation that arise from the performance of a contract or agreement in Vermont to be conducted in another state. And then subdivision 2, it says what can be in the notice. So if somebody's healthcare provider is leaving their current practice, place of employment, they can provide this notice to their patients that they're continuing to practice, their new professional contact information, and that the recipient has the right to choose a healthcare provider. Subdivision 3 provides that those healthcare provider limitations don't apply to contracts with non-clinical business support services. This is really focused on healthcare providers and making sure they have the ability to work elsewhere, open their own practice, etc. Subdivision C is simply provides that the non-retaliation and the remedies under the Fair Employment Practices Act would apply to this new section. And then there's an effective date in the statute to make clear that it would apply these two sections regarding non-exempt employees and healthcare providers would apply to agreements entered into on or after July 1, 2026. So it wouldn't disrupt any existing agreements that are already in place.
So all these provisions for healthcare employees, healthcare providers, all non-exempt healthcare employees.
No, this is a separate provision. So there's two different ones. So
What's
one,
included in the definition of healthcare providers.
so there are statutory definitions. There isn't a single one included in here, but it's a very broad definition under Vermont law. And it covers pretty much anyone, including wellness, folks that provide wellness services.
So it includes doctors down to nursing assistants at home. I mean,
Right. It's a very
home healthcare aides.
Yeah, and again, there was testimony. This provision hasn't been taken up in the healthcare committees, but my understanding is this was language that was originally anticipated to be in a healthcare bill, and then because they thought it was moving forward in H205, it got moved over
To a labor bill.
to this. Yes.
Yeah, David.
If I can, page 6, line 5, paragraph C, is this have to do with separating employees?
Yes. Yes.
So at the point of separation, they can choose their own healthcare provider. That's it. It's not about current employee deciding they want to go to different healthcare plan.
Right. This is simply that if you've got, a doctor that you're used to seeing, you show up at your practice and they say, oh yeah, no, Dr. Weeks is no longer here. And it's sort of like, well, where is he? Normally they won't tell you, like, oh, we won't say that. This is just allowing Dr. Weeks, when leaving that medical practice, to be able to notify his patients that, I'm still practicing, I've moved down the road, this is my new address. You have the right to choose who your healthcare provider is. So you could.
For a current employee.
This would be someone this would be for the employee, the healthcare employee that is leaving their current employment, that they could provide notice to their current patients as to the fact that they're moving. That would not be a violation of, for example, a non-solicitation agreement.
So I've just faced this with a dentist who I have been with for over 30 years. And she left a practice where she was a partner and I understand, it's been there for a long time, has set up a practice in Lebanon, New Hampshire. None of her patients have been given her contact information or her address or anything else. And I only learned that she had left, and she was the founding partner of this group, of her group, and then it merged with this other group. But this is an example of, I've asked them and they they aren't giving me, and so I have to I have to Google it, which is fine, I can do that, but it really is irritating. I mean, I've been her patient for a long time, and I'd like to actually continue to be her patient. And I haven't really been easily given that opportunity. So that's for me an example of this, maybe.
Right.
Maybe a modest one. Well, Randy.
Where would the person in this situation get the address and other contact information for that patient?
I would assume from the current employer that they would have a list of who their current patient.
Well, again, it's not necessarily something that's routinely available to every employee who provides professional services in the office, like a nurse or a office, some sort of an assistant who deals with patients directly.
Yeah, the intent behind this was the focus was on sort of the direct. You could send it out to all the patients
Yeah, sure.
at the practice ones you've never seen, but once that
Really
you
what I'm
are
trying to find out is there a duty of the business to provide that information if the employee who is separating doesn't have it individually?
So that's not explicitly included in here. So this was language that came from the medical society, and then
So we
there were some
Have the medical
narrowing. There was some narrowing of that language in general and housing.
It's a question I think it's bound to come up, because, I'm leaving and I want to notify my patients before I deal with of that information, but I don't have the name. I don't have my name, my first name or something, but I don't have any address or other contact information.
So
Will
Randy,
you give it to me?
we have Jess here, and maybe we could ask Jess to respond to that if that was possible.
I'd be happy to. Do you want to make
Yes,
at this point?
Sure, just stay right where you are.
Jessica
Introduce
Barnard.
yourself.
Yeah, sure. Absolutely. Thank you. Jessica Barnard with the Vermont Medical Society. We represent physicians and physician assistants around the state. So this is narrower. It's a great question. We are starting more narrowly, where the language here, the intent here is to, again, it's sort of a double negative, but to prevent prohibitions on a clinician from communicating that information to a patient or former patient. It does not go so far as to require the employer to put out that information. I believe our organization would support that as well, but that's a sort of step further than this bill goes, which is to simply say you can't include in a non-solicitation clause in an employment contract of prohibition on that provider providing that information to a patient.
I don't think that, the practice that's involved would not be particularly enthusiastic about providing a list of patients to someone that's leaving the organization.
I think that would have to be something, right, to be worked out between the separating employee and the practice. I think it also could be potentially interpreted as allowing something like a posting in a newspaper. Certainly that provider could do other sort of public announcements about, I'm opening a new practice and patients are welcome. I'm accepting new patients, but right. It doesn't go so far as to require providing that information. There are pre-existing ethical obligations that for continuity of care. So if a practice is entirely closing or a practice won't be able to care for patients anymore, say a provider is retiring or leaving and they can't stay a patient of that practice, patients in that case do have to be notified that, Dr. Weeks's practice is closing. We can't care for you any longer. Here's how to contact us for your records or next steps if you want to find a different practice. But in terms of just if that bigger practice could continue to care for those patients and one provider is leaving, there's not really an obligation to notify it currently.
I think the other piece that came up in House Commerce and Economic Development when the medical provider provisions were originally being discussed was also an anticipation that maybe the practice and the departing employee could do a joint notice or whatever, and then it would just include these elements. So
Really,
that
I
was
guess
part of
depends on whether or not the person leaving is on good terms.
Yeah, I
With
think it definitely
practice.
depends on that.
Because the practice might well just send out a note, Dr. Weeks is taking care of you the past 2 years, is leaving our practice. Your new doctor is Dr. Chittenden.
Yeah, but they sadly never do that. You just arrive and the person's gone. I mean, this happens at Dartmouth Hitchcock all the time because you have all these doctors rotating in and out, and, you know. Very hard to find somebody who's there for the long haul, except a few, which is frustrating.
Question, a different part of the.
Yeah, Thomas.
So I'm generally very supportive of banning non-compete for low wage, low earning income individuals. That makes a lot of sense to me. My concern is I do have an email from, I don't know what his name is, but he says that this is a sledgehammer. We might want to use a scalpel. So I'm overlaying his concern that this might apply to highly paid, non-exempt employees. Did the House consider, and I think other states have done this, where they ban non-competes at certain wage rates and lower, like twice the federal poverty line or twice the minimum wage? Is right now this language would in fact ban non-competes for all non-exempts, even if they're getting paid $200 an hour. Is that correct?
That is correct. Well, if they meet, yes.
So I'd propose we want to at least have an upper cap. And if an employer is going to give but a high salary, then they can negotiate.
But why does pay have anything to do with it? I mean, if you're, no, I mean, listen, hear me out. If you're a lawyer and you have left, well, I mean, that may not be because that's a salary. Well, it's not actually, it's not necessarily salary. If you are, provide a service of some variety, and you're highly paid and you part company with the partnership or the practice that you're working with, and you live in a town and you weren't able to practice within 30 months, I don't think that is, I mean, I don't know, it depends on the pay. I think pay is irrelevant in a way. It matters that if you live in a place and you aren't able to practice near where you live or where your community is, it just strikes me that is unfair.
I'd love testimony on when and why people want non-competes, because I'm pretty sure you're going to want a non-compete when you want to engage with somebody that you're sure that they can take and move to somewhere else. So if you pay them enough, I feel like it's a fair contract between a laborer, but I don't want that happening for minimum wage employees, making it harder for them to be mobile down the street. I'm not as sympathetic to a lawyer.
The reason other states use things, well, the reason other states use things like hour and wage level is because exempt, non-exempt is an extremely blunt instrument for this. You're going to leave out people who you think should be protected by prohibition on non-competes, and you're going to bring in people just based on their status as to whether or not they're exempt or not. That could result in some cases in more misclassification than actually getting at the heart of non-compete agreements.
Did you talk about other different lenses or filters to sift people through? Whether did you talk about something other than non-exempt?
So there was extensive testimony on this in House Commerce and
Right.
Economic Development in the original H205 bill. And there was huge discussion around salary levels and looking at what other states do. And there are a number of other states that have these cutoffs. The challenge was, and again, there was, extensive work done on this in House Commerce and Economic Development. The challenge was trying to thread.
Can I
the
ask
needle.
though, like, did they get to the exempt versus non-exempt early in the process, or?
No, because that's not how it was in H205.
Right, so I guess I just want to make sure we're properly characterizing how long people had to react to the exempt versus non-exempt, which is a huge question of labor law, which usually the House General Committee.
It would.
So
This came out.
that came in the House General and Housing.
So they're the ones who took the testimony and then they put exempt versus non-exempt.
They were the ones that moved forward with exempt, non-exempt as a way to target the most vulnerable employees.
But that
because
was close to the end of their.
that was at the end of the process, right? Because
Well, they took a lot. I mean, they worked a lot on this bill. I mean, it's not like.
I'm just trying to be really clear about how long we've had to understand the impact of compete, non-compete.
Right.
so.
Well, we're going to take more testimony in this next week.
Okay. So in House Commerce and Economic Development, the challenge with the salary piece was where to put the salary. And it was largely dealing with the main concern being around like startups where somebody may be paid a low salary but has, a lot of authority. They're right in the center of this new company. They've got a lot of access to very privileged materials. And so there was a real concern about where you would do the salary piece.
Yeah, Thomas.
Quick Google, 12 other states have done this with an income threshold. And
Oh.
I don't have much sympathy for that scenario, that if you want to pay somebody less, then you don't get as many assurances that they're not going to take their skills and go somewhere else, in my humble opinion.
Oh.
I feel like if you pay them a larger amount, then you can ask them and contractually obligate them to not to take those skills elsewhere. So that's why I think an income threshold has been rational for New Hampshire, Massachusetts, Rhode Island, Maryland, Virginia, Illinois, Colorado. So I'm supportive of putting a cap on this, because I think non-exempt should still be able to have a collective, what do you call it? Non-compete at certain amounts.
There's no other
Right.
states that do exempt versus non-exempt. Are you?
I'd have to go back and look. I did look all that stuff.
So I'm trying to look at, I just want to clarify, but it's no other state that I'm seeing has it.
So typically what a lot of states do is they'll have either a flat amount or they get to a percentage of the federal poverty level.
Or job functions or industry specificity.
Right, so there was a lot more specificity in H205. So again, this was an effort to move forward with a portion of H205 to get something through for what was perceived to be the more vulnerable workers. And to
That's
address the
accepted.
healthcare providers. So yeah, I mean, I think if there's a salary level, one of the things you would want to consider would be having a mechanism like a percentage of a level, so it's not stagnant. The problem when you say $50,000 is then in 10 years' time, that's not a good number. If you say it's twice, for example, so one of the
Right.
mechanisms they looked at was the
State
state
average or
minimum
something.
wage, right? So the state minimum wage, if you were paid that for a full year, is around $30,000. So you could say, 200% of the state minimum wage, which would make it 60,000, or 3 times the state minimum wage, it would be 90,000. So having some mechanism whereby
But there's a real
the-
value in having interstate commerce work. I mean, people switch jobs, their non-compete might apply to a very specialized job where people move around the country for these jobs. So it's really just not a good idea in my mind to have a completely different standard than the other states.
I'm hearing that. So, we have a witness that Austin Davis has given us on this, and any other witnesses that would, please let us know. We're booking them in for next
One issue also
Wednesday.
is just the duration of time for non-compete. I currently have a non-compete that I've had, I think, for 36 years. Now, because of my special skills, just like the person who's a COBOL programmer, is not in great demand today, except in here. We got those programs still operating.
How can a non-compete last for more than 2 years?
Well, it does, it's unless it's specified.
So typically courts would look at agreements not to compete, and they look at reasonableness. So whether it's reasonable in scope, it's reasonable in the amount of time, it's reasonable in the geographic area. And as you say, that can vary widely. It could be global, it could be 10 miles. I mean, you just depends on what the particular activity is. But again, if you're a unique person that has some specialized knowledge that could be beneficial anywhere in the world, it could be global and not.
There's been a lot of confidential information, for example, about the business that you work for. And that business is still in operation, and that confidential information basically be valued.
So this wouldn't preclude non-disclosure agreements or non-solicitation agreements or other types of
Right.
agreements or, trade secret protection, et cetera. It wouldn't eviscerate any of those protections.
Thomas, and then we're gonna
Just
switch.
echo what I think I heard Senator Hinsdale say, which I don't support just having exempt be excluded from this, because there are assistant general managers that'll make $43,000 and $45,000 a year that are also asked to work 55, 60 hours a week. So you do the math out, and that gets back down to minimum wage. I think looking at a salary threshold to apply non-compete restrictions on is what other states have done. That's a lot better approach to achieve what we're after. So
Well,
that's right.
Great, so we're gonna take this up again next week. If you have, Austin's given us a chat whose name, anyway, we have, somebody who's weighing in. If you have other people you want
I
to weigh
emailed
in.
everybody a lot of information that I found on what other
Oh,
states do.
Thank you. Okay, thank you, Sophie.
You're welcome.
And, I understand we have time challenge for Cam. Maybe, so let's shift to 7:57. We wanted to wait till David Hall got back, so David, why don't you start? And it, because there were sections of 757, which I have to pull up, that we were waiting for to hear from you.
Sure.
Okay? 2 days in a row.
That's great. I'm here to do. Cool.
What is this one?
I don't know.
Is it
I never know why I'm here.
Okay.
I just show up.
This
But
is not manufactured, this is manufactured homes and limited equity cooperatives.
Awesome.
That's
757.
While you're looking,
still have asked us by the house.
Yes.
while you're all looking, and I'll introduce myself, David Hall, Director of Business Service Division, Secretary of State. I will pitch to you. This morning we had what I would call the initial or preliminary meeting of the Act 10 stakeholder engagement process. Very exciting, great attendance, and it occurred to me that one or more of you may wish to join or at least be included in the progress we make over the course of this year. People from this committee, people from finance, ways and means, commerce, I would like to at least be aware of the work. So, you might see an email from me to that effect. And if you want to play along or join us, I would welcome you. That is Act 10. You may remember what's the business bill we did that updated, harmonized a lot of provisions
Yep.
about our processes, and the next iteration of that is studying on where do we go from here with business organization laws, filing requirements, fun things like trademarks and service marks, all kinds of stuff. So, and culminating in a report to the legislature in December, and I hope legislation in the next biennium. So, be on the lookout for an email from me.
Great. I think you are here to talk to us about limited equity cooperatives.
I think so.
Pam still here? I believe that's
So,
what you were weighing in on.
yeah, I think you had a couple of questions on that relating to their status and what this part of the bill does about updating their status, so to speak. I have to tell you, it's really born of two things: a historical error, and I think maybe a misapprehension or a conflation of what it means to form one of these things at the state level versus your tax status. And that's really where the divide occurs. So we are in the universe of business organizations. That's why I'm here. We form and register most of them in this state. Included among those is a housing cooperative corporation. That is a type of corporation, just like it sounds. But it is a type that is formed and has always, to my knowledge and my research of legislative history, has always been formed under the umbrella of business corporation law, not nonprofit corporation, but business corporation. That was formally governed in Title 11 in Chapter 1. And then when you adopted in 94 Title 11A, you adopted the Model Business Corporation Act. That is the standard, the gold standard, the ABA promulgated law that governs business corporations. And that's important. It's important. It should be important for these entities because we're talking about ownership interests. And in Vermont and in most places, nonprofit corporations don't have ownership interests. They are members in these organizations. They have voting rights in its governance, but they don't own the business. They don't, and when the business owns things, when the business dissolves, generally it is required to convey its assets to other nonprofits. And that's part of what being a nonprofit is, right? So here's where I think the problem arose in the historical record. And it's lost to history in my office because it's a long, long time ago. But at some point, somebody, and I think it was in the period of time when there was not a director of my division that had been folded in with another division, and there was nobody sort of maybe
With eyes on it.
with eyes on it. There was confusion about these limited equity co-ops and how they were characterized in the record because they felt very legitimately that we operate on a nonprofit basis. Some of them have nonprofit tax status. we're a nonprofit. Well, there's a difference between your state level organizational structure and your tax status for the IRS and the state. And in a very, very narrow, because of a private letter ruling and some rules that were adopted by the IRS, it is a very narrow path through which a business corporation formed on a limited equity cooperative basis for housing purposes can actually qualify for IRS tax exempt status. That is not typical.
Right.
That is not typical, but it's there specifically to allow these types of entities to exist and to benefit from tax exempt status. But they have to be very specific in how they are formed and how they operate. There's 2 tests they have to satisfy, not just what you do, but also how were you formed. So that's why these provisions are what they are in the law about how much you can charge for rent if you rent the place, if at all, how many people on the board of directors can be owners, what has to happen to the assets upon dissolution, etc. So they're doing all this stuff to satisfy
So
tax requirements.
as technically business structures to qualify as a nonprofit for tax purposes,
Right.
they're having to do 2 things. What to walk this narrow line. They have to form,
At the state level,
How they
form a
form.
corporation
yeah,
that
How they
has
form its
structural
corporate-
elements in its articles of incorporation to satisfy regulatory and tax requirements to get tax
right.
exempt
So
status.
that's how they form.
Right.
And then what's the second one? You said number 2.
There's 2 tests.
What's the other test?
I was referring to the organizational and the operational tests, which are the litmus test for nonprofit, don't say nonprofit, say tax exempt status. Tax exempt status, you have to have in your organizational structure the provisions that they will read and say, you check all these boxes in the way your documents are actually written. And then in the way you operate the thing, you also have to satisfy the tax exempt test. And that means you can't just form a shell and then start making a bunch of money and try to hide it.
Right.
So, long story short, these were all actually or should have been business corporations all along. The reason that this is in the bill is because I think the people out in the world think they're supposed to be nonprofits, but they're not. For our purposes, they're supposed to be business corporations who are able to pursue tax exempt status if that's what they choose to do, but that's not up to me, that's up to the IRS. But to say that some of them are characterized as business corporations, some of them are characterized wrongly as nonprofit corporations is the status currently. And the request, the language says we could fix the record if that's what somebody asks us to do. But I think what they're asking, what they were hoping was that we would change all the profits to nonprofits, when really it's the reverse. If we were going to correct the record, we would be changing the nonprofits to profits. I don't think they want that. But I'm not sure anything's going to happen here. I mean, you can pass the language.
So we're putting the onus on each individual limited equity co-op to come and work this out with you.
Well, you're giving us express authority to change our record if they request us
If they request, so,
to properly reflect their status.
right. So are you,
What does that mean?
and what does that mean? So
Well-
Cam would like to weigh in here too. Cameron might want to weigh in here too, because we've gone through this. So we want to give them that opportunity so that they can take advantage of their non-tax status.
Now, I want to be really careful here. I think what they think they're asking for is to tell us change all the profits or business corporations to nonprofit status in our records.
But they,
What I'm saying is what would actually happen is we would change their nonprofit status to for-profit status. I don't think anybody's going to ask us to do that once they understand the implication. So I'm saying this provision probably does no harm because I don't think anybody is going to avail themselves of it, but maybe they want to. I don't know.
so there's no, David, did you have a question? I saw you. Okay. No, I'm trying to, you're right, it is confusing. So there's no, are there some of these, company? Are there some of these corporation cooperatives that are treading the line and are functioning as business entities, business corporations that have have effectively done what's needed to then be able to have a non-tax status?
I have no idea in the real world if they have
So you
pursued
can't see
tax
that from
exempt
their
status.
records or how they're filing.
No, because that is there's a wall between
Between
your
you and
tax
tax.
status and your state corporate status. And I don't care about the former. I only care about the latter.
No,
And
but you do, because you also carry the records of nonprofits, don't you? In your,
for
if they
state
form as
organizational
corporations.
purposes,
Yeah.
not for tax purposes.
No, but you know how they're organized. I mean, they are either
And yes, and
profit or not.
that's what I mean. That's the part that matters to me.
Right.
And what I'm saying is the law that governs formation of this type of entity is the business corporation law. It is not the nonprofit.
So if a mobile home park was thinking of changing its business structure, and if they're going co-op or if they, whatever they would, they would in most likelihood come to you to talk with what business structure they wanted to choose.
I can't give people advice on that. That's legal advice on what you should do. Here's what.
So what this gives them an opportunity to change, what I think I hear you saying.
Yeah.
Is this gives these cooperatives an opportunity to change their status, but it may not be able to change it the way they're anticipating.
Yes.
This is not going to
You got
enable
it.
them to change it to nonprofit. This will only enable them to change it to for-profit.
Right. And
So-
at least in the characterization of our records, right? You'll search for this business. And
But-
instead of saying nonprofit corporation, if they ask me to change it, it will say profit corporation.
But if they do that, you sort of cure it, because we're using the language of cure it this
Yeah.
morning in this committee.
Sure.
If they, are they then able under that umbrella, are they also then able to tread the narrow line of being able to continue being tax exempt?
That's it.
Sounds like there's a narrow way they could do
There
that.
is, and there is, and so that's the danger of conflating the state organizational structure and the tax exempt structure for tax purposes. And the bottom line is right now they're listed incorrectly.
Right.
In our record.
All of them?
I don't think all of them. Some of them. There's like 11, and I think I'd have to look back, but maybe half or 8, 3. Or
Have you contacted them to let them know
they've
that?
contacted us. This has been going on for a long time.
So they've contacted you because IRS has denied them their
No,
tax status?
no. Keep for a moment. Keep the IRS out of it. When they go for grants
So
to
that's to fix.
or other
the
sources
infrastructure
of-
fixes or whatever.
of funding, they think it's a problem that they're listed as a business corporation or a profit corporation instead of a nonprofit corporation, and based on their corporate status. When the reality is, they are formed under the business corporation law, so they are a domestic business profit corporation. And they could also be, and in some cases, I believe they are tax exempt. So both can be true, but people are, again, conflating the tax exempt status and the organizational structure.
So I appreciate that.
Yeah.
So I can appreciate this. If they come to you in at taking advantage of this opportunity to get them into that narrow path, are you able to help them with that, or is that a lawyer who has to help them with that?
I don't get involved in the application for tax exempt status, but that's something they can pursue.
But it is something, this bill gives them the opportunity to sort of cure a mistake, a historic mistake.
It gives them the right and us the express authority to correct the record. And all I'm saying is it's not going to flow in the direction that they want. It's actually going to flow in the opposite direction.
Well, but what you're saying also is that if they have a lawyer and they are working on trying to find this narrow path, they could find it.
Yeah.
So they're not all going to be negative necessarily.
So the lawyer and the tax exempt status and all that is beyond me. That's after me. That's IRS. The record, the organizational structure, how it's listed in my records is just what kind of organization are you? Are you formed under and governed by 11A because you're a business corporation? Or are you formed under and governed by 11B because you're a nonprofit? And the correct answer is housing cooperative corporations, of which limited equity co-ops are a subset, are formed under 11A, period. The record incorrectly says that some of them are nonprofits formed under 11B or governed by 11B, and that's wrong. So again, the 11A, 11B dichotomy is what my office is concerned with, if you can think of it that way.
And 11V is the nonprofits.
Nonprofit corporation as a structure, as an organization type sanctioned, authorized by the state, into which we breathe life into an entity.
Yep,
The tax exempt status
is
is
a separate.
an IRS question. It's just like anybody else. You go, you apply, you
But
demonstrate.
you somehow know.
Yeah.
Even though you're only looking at the structure, business structures,
Right.
you somehow know that some of them are actually treading this narrow path.
Well, because you're, like I said, so the organizational test for tax exempt status is that your organizational documents have to have, 1 through 6, how you're formed. That's the organizational test. And so I see the articles of incorporation that have been submitted, and I see that you've included these pieces to be a limited equity co-op and to check those boxes for this narrow path. So that's how I know that you were at least organized with that in mind. I don't know if you've actually gone to pursue it because that's not my business, but I know that you're set up that way.
So who's letting them know that they are not in compliance with the law, that their structure is
So
incorrect?
I believe the way this is triggered is they go apply for a grant or a loan.
Right.
They give their articles, the articles of incorporation say, this is a Vermont business corporation, or this is a Vermont
You're
profit
not
corporation
eligible for
from
this.
under 11A, therefore you're not eligible. That's probably not right. I mean, they can, because if they're tax exempt, they're tax exempt. So the question I don't know the answer to is, in the pantheon of grants and loans, is it predicated on the organizational structure or on the tax exempt status? I have no idea. But I think that's the communication vector.
And so while Cameron is here, we can have this dialogue, and so that this bill fixes that. Or
Where is
it
it?
enables a cure. I mean, I'm trying to understand what we're doing.
Yeah, fair.
Are you clear on what we're doing?
I'm clearer
Yeah,
on this presentation.
yeah.
I'm trying to pull up this.
I'm not sure what we're solving with this.
So I, for the record, Cameron Wood, Office of Legislative Counsel, I 100% agree with everything that Mr. Hall is saying. And I think he is articulating it in in the best way humanly possible.
For a complicated mess. I
Um,
mean,
but there is an issue. And the resolution to the issue is not what the advocates who are asking for a resolution want.
so why did they,
It's one thing.
why did they pass this if it's not what they want?
Because there's a separate provision in here that somewhat addresses what the request is. So I'm gonna,
Okay, so it,
I'm happy to deal with the chair if you.
no, it's okay. It's fine. We have only 10 more minutes, so I would.
I'm
That'll
trying
take time.
to get to a Zoom link so I can potentially share my screen. Give me a second.
So while you're doing that, so some of these, of the 11 cooperatives that we have, roughly half have figured out how to be formed as a business structure. And have figured out this narrow path of the,
I don't want to characterize it that way. It's more rudimentary than that. It's that some of them are correctly labeled and some of them are incorrectly labeled.
got,
And that's what I know.
and that this bill allows them to come back, correct their status with you and figure out if they need to for grants or other things, figure out with their lawyers or whoever, how to find this narrow path so that they can also have a tax structure that works for them. Yeah, what's that, right?
I think that's a plausible explanation.
Thank you.
Yeah.
Trying to find one.
I,
Don't know how that.
I think the point Cam is about to make is important about the grants and stuff.
Yeah.
Okay,
So,
what page are we on?
so this is page 8.
Sorry.
So the issue is you have some of these entities, as Mr. Hall was mentioning, you have some of these entities that are registered as nonprofits, and then you have new ones that are coming in. They're saying, hey, why are we being registered as nonprofit? You see this sister park over here that has the exact same structure and the exact same articles of incorporation. Why are they being treated differently than us? And the reality is, the straightforward answer is because you're being treated correctly and they were incorrectly registered. Okay, and so there is no way to resolve that issue because the resolution is, as Dave's pointing out, is to go back and re-articulate the ones that are done incorrectly in a way that they don't want. And so that's why the committee landed on the language that you have at the bottom of the bill, which says if the entity wants to, they can request that their status be updated correctly. I agree with Mr. Hall. They're probably not going to do that because in theory, they're losing the advantage that they feel that they have by being listed as a quote nonprofit. Okay.
Where does
So-
it say they can do that?
That's what you all were talking about here. on the
Nothing in the
bottom of
section shall be
page-
deemed.
Nope, look at the very end of page 11,
Oh,
section
the
7.
variant.
Secretary of State may, upon request, update a limited equity cooperative's registration to ensure proper reflection. That's the discretionary language that's in here that allows them to request that their status as registration with the Secretary of State be updated. I don't imagine that any of them are going to avail themselves of that ability. So then what the House General Committee also added in was this section at the bottom of page 8, which says that a mobile home park organized as a limited equity cooperative shall be treated for purposes of state funding and grants as if it were incorporated as a state nonprofit corporation for a public purpose and a public benefit of the
okay.
laws of the state. So there's a few concerns that I've raised with this language previously in that you're treating mobile home park limited equity cooperatives different from other limited equity
You're giving them
cooperatives.
special status.
Right.
You're saying you don't have to be correctly registered to take advantage of these opportunities.
Correct, but as a public policy point, the argument here is a limited equity cooperative. They're the assets of the cooperative are limited in statute and treated in a way that is similar to a nonprofit entity. As we walked through last time, we talked about this language. When you look at the section that governs limited equity cooperatives, if the cooperative dissolves, any assets remaining after the cooperative pays off its debts or pays back its members their share, that remaining assets have to be distributed to another limited equity cooperative or another nonprofit. So you've limited how the assets of this corporation can be distributed once it's dissolved. And you've articulated that the public purpose of a limited equity cooperative is to serve low and moderate income individuals. Remember, we talked about the definition of low and moderate. Those are the individuals who are able to be members of a limited equity cooperative. So in statute, you're somewhat treating them as if they are similar to a nonprofit with a public purpose.
Because it has a
And
public
they're
good.
bound, right?
Right.
So the policy question on B1 is, why are you limiting this to only mobile home parks that are limited equity cooperatives? Conceivably, other limited equity cooperatives serve the same type of purpose as a mobile home park. That's the first question you all, I think, need to address. Separate from that, I think, is the broader question of, this is a very broad stroke in saying that if you're a limited equity cooperative, you're treated as if you're a nonprofit for all state funding and grant purposes. That's a public policy decision that you as a committee have to make, whether you're wanting to treat them all that way.
I think that the issue that people are raising is because some of them are registered incorrectly and registered as nonprofits, they aren't having to jump through the same hoops and overcome the same barriers as other similarly situated entities that are not being registered or have not registered as the nonprofits with the Secretary of State. And that all comes back to, why are they different? Why are they registered different? Why do we have this challenge to begin with? All that comes back to the information that Mr. Hall has been sharing this morning. It is an error that was done years ago, and that is the landscape that you're dealing with now in the city.
So we're trying to fix the error in a very narrow circumstance. Mobile home parks that are formed as limited equity corporation, cooperatives. How many other limited equity cooperatives are there that are not mobile home parks? Do you have a notion of how many?
I don't know off the top of my head. There's a few, but they're not just mobile home parks.
Can you,
Primarily housing. Just-
Yeah. Oh, these are all these are all subsets of housing cooperative corporations. So
so
a handful, 5, 6, not mobile home parks. If you're in Burlington,
and they are apartment buildings generally, but they're not.
I couldn't
You can identify the entities though.
Yeah. Let me make 2 observations on this. It's true that historically, for whatever reason, there is a characterization or classification error, right? If you look up this entity and it says, here's such and such limited equity co-op, nonprofit corporation. That's the database. That's the database you look in to find it. It doesn't change its articles of incorporation, which were filed properly and are under. So it's not even a question of whether this was organized properly or not. It's really not. It's like the label is wrong. Do you know what I mean? In law, legally, these are all profit corporations because of the way they were organized, because of the law under which they are organized. The error, the historical mistake is just a label. It's a classification error in our records. That doesn't change the nature of the entity, first off. Second off, I guess I would observe about that language about, deemed to be a nonprofit for purposes of grants and such. I would almost question whether you should be framing it in terms of treated like a nonprofit corporation, which again is an organizational structure, or you should be framing it in terms of tax exempt.
Yes, as opposed to nonprofit.
Right, because again, you could be organized in lots of different ways and still be tax exempt if you apply and are approved by the IRS. To get there, you've got to meet all the substantive requirements that are in the law, and they're there because they correspond to the tax requirements. So that would be something I guess I would,
So, and,
suggest you
and,
consider.
oh, and then the challenge for us in our limited time here is that the grants, what they're trying to bend over backwards about is trying to get in so that they're eligible for some of these important grants to improve their mobile home parks.
Right.
We don't know the language in those grants. I mean, we could certainly
Right.
find out
Yeah.
whether they say tax exempt or whether they say nonprofit.
Yes. And I don't have any sense of the universe. I know TEC managed some of them. I know a lot of them have.
He does the HDD,
Right.
he does,
So-
like we can ask
Yeah.
Alan, but
So,
so that's an assumption that they're making, that nonprofit versus tax exempt. Sorry, we need to go to the floor.
Yeah.
Any other questions for David? Cameron, thank
You're
you.
welcome next time.
I'm happy to come back whenever you want.
Thank you.
Sure.
And
One question that I've got about, I think the legislative, do something else of correction, if you will, for any entity that was formed under these, that is officially operates as a nonprofit organization.
Sure.
Can you allow the holder of that to change their classification and that the state will recognize it. This is in our corporation law.
I mean, so
That's you correct an error. no?
that's how we got to the correct error
Yeah.
language, because
Yeah.
if you had mandated it, if you said shall correct the record to reflect properly its formation and structure, then all of a sudden,
Really, that was-
these entities that think they're nonprofits would wake up one day and find, oh shoot, the state just changed me to a profit. I didn't want that. That's why it's permissive, not mandatory, first. Second, at this point, because again, it's a function of the legal framework under which they're formed, you'd have to actually undergo a conversion from one type of entity to another to actually become a nonprofit. And when you do that, there's all kinds of complications, taxable events even, because the ownership structure changes
So-
from one kind to another.
Thank you. We need to go.